Good afternoon, everybody. This is the fourth in a series of presentations my partner and I are doing about getting your business documents together in order to protect yourself in the long run. My name is Michael Einbinder. I'm a partner in the law firm of Einbinder & Dunn in New York City. And what we want to talk about, and what we have been talking about, is the fact that most people in business do not spend enough time making sure that their documents, their internal documents, their shareholder agreements, partnership agreements, and the like, are established and set up in the right way. And they don't look at them after they've done them when they start their business. And what we have found is, what we've done is given a lot of advice to clients about how it's necessary to keep looking at those documents as your business evolves. And what we found is that what happens when people don't listen to that advice is they find themselves in some kind of trouble. And we have a lot of experience in this area. We're business lawyers generally. I'm a trial lawyer. I'm also an American Arbitration Association arbitrator. At least 25% of the cases that I have in my own practice, as well as about 60 to 70% of the cases I do as an arbitrator, involve corporate divorce. When partners in a business have a falling out, they often go to court or they go to an arbitration proceeding. And what we have found is that old documents done when people start their businesses, are the worst way or worst document that they can use to try and establish their rights and remedies and obligations to one another when they do get into a fight. So what we do as lawyers sometimes when we're discussing these kind of things with clients is we give war stories. And I've mentioned this before in other presentations, but it's really one of the most egregious examples of the problems that we've seen. In one case a while ago, I was an arbitrator where the parties had been in partnership for about 25 years. They valued their respective interests at about $25,000. The company was probably worth $5 million at the time of the dispute, but when one of the partners died, they tried to get out their other partner's spouse by paying her $25,000. And the fight ensued over how much it was worth. At the end of the day, the business was really worth about $5 million, and she would have been entitled to $1.25 million to get out of the business, but she didn't have the documents to prove it. And we've seen this in a lot of cases where shareholder agreements don't explain the rights and obligations of the parties, where someone's fired by one of their partners and who has a right to do that, and they don't have a right to stay in the business that they started. We've also seen it with non-compete issues where partners in businesses end up fighting about whether or not the partner can continue to operate in the business that they've been accustomed to, but for another entity, and whether or not that non-compete stops them from doing it, or a lack of a non-compete puts them at risk. So we advise people to look at their legal documents, and we're happy to do it with you, so they can ascertain what their rights, obligations are, and what they should do to straighten out those documents in order to make sure they're protected down the line. Thank you.